third event, and I'm the Managing Director of the Canadian Jewelers Association. And we welcome everyone who is still logging in, so we will be waiting a couple of moments. You're joining a fantastic webinar today. It's our April AML one-on-one. And for everyone who is on the line and who is giving us our time today, we're very grateful. You're going to be learning lots today. And from CJA, we would like to let everyone know, I'm sure you know who we are, but if you don't, we are the voice of the Canadian jewelry and watch industry. And we represent a membership consisting of retailers and suppliers, designers, wholesalers across Canada. And we're here to provide leadership in ethics, education, communication, and prevention, crime prevention. And whether you're new to the anti-money laundering or looking for a quick refresher or needing to meet some of your staff training obligations, this is the webinar for you. And we'll review some basics, discuss Canadian compliance obligation and common red flags. Attendees are welcome to submit all their questions in the Q&A window at the bottom. And quick housekeeping rules, we ask everyone to keep an open and positive atmosphere throughout, and everyone is muted for the entire time. Please be polite and respectful, and your questions should be asked politely and respectfully, and if we can't get to them, we will answer them privately to each and one of you. So we won't forget about them, not to worry. And today we have with us our beloved guests and trusted partners, Amber Scott and David Vijan from Outlier. Hi, guys.
Hi, thank you for having us.
Looking beautiful, Miss Amber. You too, David. Handsome as always. Outlier Solution is a Canadian consulting firm founded in August 2013, and they're focused on developing compliance solutions for reporting entities. Their areas of expertise include Canadian anti-money laundering, counter-terrorist financing, privacy and regulatory compliance. And they've created an online on-demand anti-money laundering and counter-terrorist finance compliance tools for dealers in precious metals and stones, including wholesalers and retail jewelers. The toolkit is free for Canadian Jewelers Association members. So that's one of our biggest benefits if you are a CJ member. And if you're not, this is one of the best reasons as to why you should belong. Non-members who would like the kit typically pay around $2,700 for the compliance kit. So that to introduce you all as to why AML is so important and why you are all here. And Amber and David, I know we have an hour packed. So I don't want to take more time, but I hand it off to you and let's hear about AML and what we need to know.
Perfect. Thank you very much, Beatrice. And I think as a starting point, if we could just put up the poll, which is anonymous and it's just from a curiosity perspective.
Valentina, we have yes, perfect.
There we go.
There we go. So that's to spice things up a little bit and to help us understand where everyone is in terms of compliance and do you have a kit? So everything is anonymous, obviously. You don't have to be afraid of that. It's to give us a better understanding. And Amber and David are excited to see the results, just to see how our trade is doing and how prepared are we, right, Amber?
Exactly. So it's just to understand the starting point. There is no obligation today that you have any one of these particular answers to go through the course. We will walk through all of the basics and then get into some of the nitty-gritty of the obligations that you have as a Canadian jeweler.
So we're going to give it one more minute, and we strongly encouraged everyone here to help us with the poll and see how we're doing. And Amber and David, hopefully it's okay with you, but we're recording the sessions. We have a couple of members of ours that could not make it today. So the recording will go out to everyone who is attending today and beloved members of the associations who could not make it. It goes to members only and attendees. So everybody can listen in their own time.
Excellent.
Are we good with the poll?
I think so. Let's take a look at the results.
Okay, so look at the results. That's good. I'll let you see that, Amber, but majority uses Outlier kit. So some have their own. So that's good. everyone is familiar at least with AML. So ready to go, Amber?
Ready to go. So let me know if you can see my screen. You can see the presentation?
We see it very well, Amber.
So I will start with just a couple of quick hefty disclaimers because we are compliance geeks. David and I will be talking about law and regulation today, but we are not lawyers. Nothing that we say should be interpreted as legal advice. Similarly, we're going to talk about government organizations, primarily FINTRAC and how they operate. We are not official representatives of FINTRAC, and what we say should also not be interpreted as the official will of FINTRAC or the Department of Finance or any other government agency. And if you have questions about particular situations, and what I mean by this is, you know, if you have a question like, hey, Mike Smith did something that seems really shady at our Welland location last week, should we report this as suspicious? I would ask that you either wait and follow up with David and I offline, or find a way to express that question that doesn't get into the specifics like Mike Smith at our Welland store, especially if it's identifying information about a particular individual or location. And I think that's always important to mention because we will be talking about suspicious transactions a fair bit. And finally, we're big believers in the idea that information should be free. So if this presentation is useful to you, then get in touch with Beatrice. Feel free to get a copy of it and share that with your staff and other folks that might not have been able to attend today. So we're going to start off just talking about the basics of money laundering and anti-money laundering. Generally speaking, whenever there's a crime that generates proceeds, profits from that crime, any attempts to move or to hide that money to make it look like normal money from the legitimate economy is money laundering. And this can take place in a variety of different ways to move that money through the legitimate financial system, to make it harder to follow that trail, and to make it appear as if it was legitimate. This is often described as having 3 steps. Placement, which often occurs in cash, but not always, is where the money is placed into the financial system. And then we have layering, where funds, goods, products are moved back and forth. They might be moved between different individuals, between different entities to make that trail harder to follow. Generally speaking, when you have hops between different financial institutions or reporting entities between different countries, all of those things make it more difficult for law enforcement to follow the trail of the money. And finally, we have integration, where the funds appear to be legitimate and they can be used to purchase goods or services. This can include investments, and those may be investments in precious stones or precious metals. Then we have terrorist financing, which is a little bit different in that terrorist financing, rather than beginning with a crime as money laundering does, ends with a crime. So you have funds that are raised that are intending to support violent and illegal actions that are generally intended to induce fear or panic, to influence governments through violence. And so those types of things are known as terrorism or terrorist acts. Money that moves through the financial system to support terrorist acts might come from a place that appears to be legitimate. In the Canadian context, we've actually had a number of registered Canadian charities that have been either knowingly or unknowingly co-opted to raise funds that ended up not going to support food for people in need, but things like rocket launchers. And so those are things that we do have to be cognizant of. It's not enough to say that we don't think that it happens here or that we think that Canada is relatively low risk. We have responsibilities as reporting entities to be vigilant for these types of activities. As I mentioned, money laundering begins with a crime, where terrorist financing ends with a crime, but the ways that the money moves through the financial system can be very similar, in that in both of these types of situations, you have things that appear irregular because the goals of the transactions that are being conducted aren't the same as they would be for regular folks. In fact, part of the goal is to make it more difficult to follow the trail of transactions. Dealers in precious metals and stones, or DPMSs for short, are one of the types of reporting entities in Canada, along with banks, credit unions, money service businesses, real estate companies. So we have a number of different types of reporting entities. You are one of them if you are buying and selling precious metals, precious stones, or jewelry that's made from precious metals and precious stones. We got a clarification from FINTRAC recently. We know there's been a lot of interest around lab-grown diamonds, and the question came up of whether or not lab-grown diamonds would be considered precious stones for the purpose of this legislation. So we went out and asked FINTRAC for an opinion, and the answer came back as yes. So the law is agnostic as to whether or not a precious stone is grown in a lab or mined from the earth. And that's important to know going forward. There are some relatively limited exemptions that exist under the law that say that you may be doing some of these activities, but you're not regulated as a dealer in precious metals and stones. Those are businesses that are engaged in manufacture, mining, cutting and polishing, and these are very limited exemptions. Exempt entities might have sales that are specifically to employees. So they might be able to offer some limited products to their employees without being captured under the legislation. But that's the extent of that exemption. So as soon as you start having sales that are to the public, to friends and family, to folks other than employees, there starts to be a good chance that you get captured under this legislation, and that exemption that might have applied to you otherwise no longer applies. And that's something to be cognizant of. Those situations tend to be very specific. And one of the things that's important to know is that if you think that an exemption applies to you, you can always write to FINTRAC and give them your business model and say, here's what we do. Please confirm that this exemption applies to us, and they will do that. If that's something that you need, we can get you the email address and help you structure that question. But generally speaking, most companies, especially companies that have sales to the public, are going to be captured under this legislation. And where that's the case, you're required to comply with Canadian laws. The regulator in this case is FINTRAC, which stands for the Financial Transactions and Reports Analysis Centre of Canada. They are Canada's financial intelligence unit. So they receive a number of reports from all of those different reporting entity types that we talked about. They liaise with law enforcement across the country, as well as with foreign law enforcement to provide them that intelligence. They also oversee all of those types of reporting entities that are regulated from an anti-money laundering perspective. The consequences of non-compliance can be relatively severe. There are fines and administrative monetary penalties. These can range up to millions of dollars. They're adjusted based on business size. So the intent of a monetary penalty is not to be punitive, but to encourage compliance. There was a change in Canadian legislation recently where if there is an administrative monetary penalty and it meets certain conditions, publication is mandatory. It used to be that companies could negotiate to not have their names published if there was a penalty, and that's no longer the case. This is fairly important in that if your name is published as being in violation of Canada's anti-money laundering standards, it becomes very difficult to maintain banking relationships and to maintain good relationships with your suppliers, because it becomes a matter of public record that there has been a compliance issue previously. And the final one is criminal penalties and imprisonment. And this can generally only be applied where someone was really complicit. And what I mean by that is that it's not an oops, I was trying my best to have a compliance program and I made a mistake and forgot to submit a report or submitted something late. But this is really, we are the gold dealer of choice for the Cali cartel type of territory. So you knew that something was quite offside. You were very complicit in the activity, and that's where you would see things like criminal penalties. So I don't want you to worry that that's something that's going to happen when you're trying your best and running your business. That's certainly not the case. That's really complicit criminal activity. In terms of the penalties that we see, these are known as administrative monetary penalties, AMPs for short. For a while, FINTRAC wasn't issuing penalties. From about 2016 to late in 2019, because there had been some court cases where they were advised that they had to provide better information about how they were assessing penalties. So in late 2019, they actually re-released their manual in terms of how they would assess penalties. There's very detailed information on FINTRAC's website about what that means. And we have started to see new penalties, and those are being published on FINTRAC's website as well. We have not seen a penalty in the dealers in precious metals and stones industry recently, which is good. Keep our fingers crossed that we're on the right side. But it's inevitable that every industry will have some of these new penalties eventually. David, I'll turn it over to you for this section. Just let me know when to advance slides.
Yeah, for sure. So now we're going to talk a little bit about the actual obligations that you have as a dealer in precious metals and stones. Amber, you can go to the next slide. So what are your responsibilities under Canadian law? There are two parts to it. One is you have to have a compliance program. And then the second part is you have to do certain things from an operation perspective to make sure that you are compliant with the law. The compliance program consists of 5 elements. The first element is you need to have a compliance officer. Compliance officer essentially is someone that is tasked with the overall accountability and responsibility for a compliance program. This person, in terms of a special designation, there really doesn't have to be, but they need to be aware of Canadian AML requirements. And also they should be senior enough within your organization that they do have access to senior management. If they are not a member of senior management, essentially they should be able to make decisions without involvement from senior management. Next is policies and procedures. And this is where the toolkit, which we mentioned earlier, will come into play and help you out. The policy and procedures basically outline all your obligations under Canadian law and how you comply with them. Risk assessment is your third element, and the risk assessment essentially is a document that outlines all the possible ways that your business can be used to launder money, but all the controls and mitigating factors that you have in place to make sure that that doesn't happen. And that is also part of the compliance toolkit, which we'll talk a little bit more about later, hopefully. The fourth element is a compliance effectiveness review. This is an obligation to have an audit done that looks at your AML program and your operations every 2 years. It is different than a financial audit, but it is similar in terms of ideally this should be independent. If you are a smaller organization, sometimes that's not possible. There are consultants such as us that can help you out and do that effectiveness review. But ideally, if possible, it should be done by an independent party as opposed to someone in compliance. Internal audit would be a perfect example of that. And the last element for your compliance program is training. Staff have to be trained at least annually, and this is staff members that deal with customers or would deal with customer transactions. And really there, a lot of the training is going to be about suspicious transactions and what the obligations are under law. From an operation standpoint, and we'll dive a little bit more into these in the following slides, reporting, there's certain types of reports that need to be sent and submitted to FINTRAC within certain time periods. Record keeping, it's important to document and keep records of certain things, and we'll talk a little bit more about that. Identify customers. In certain situations, you are obligated under the law to identify customers. And identifying customers is very specific to, as I said, particular transactions, but how you identify customers are also laid out in legislation. Customer risk, so you need to be aware of who your high-risk customers are, and transaction monitoring related to those high-risk customers. Amber, you can go to the next slide, please. So record keeping, there is an obligation to keep AML and CTF program and operation records for at least 5 years. The record should be maintained in a format that it's easily accessible and retrievable. Typically, if FINTRAC requests any records, you do have about 30 days. You have 30 days in which to comply and get those records to them. There are certain types of records, and a lot of them are going to be, actually, I'll name kind of the most important ones for DPMS. So any reports to FINTRAC need to be kept. There needs to be a record. FINTRAC obviously would have a record, but you are obligated under law to keep your own records. Client identification. So in certain situations, when you identify customers, you have to keep information related to that customer. The law doesn't obligate you to photocopy an ID, even though we know that a lot of dealers in precious metals and other industries tend to do that. It's about keeping the information, and we'll talk a little bit more in the identification section what particular records need to be kept. Training, I mentioned training earlier, so you need to keep records of training, when it was completed, by who, and the date of training. You also need to keep a forward-looking plan, so when the next training will take place. We mentioned the AML compliance effectiveness reviews. The reports with senior management sign-off has to be kept. And then a lot of the day-to-day stuff. So any sort of transaction monitoring, enhanced due diligence, those are the types of records that need to be kept.
In essence, if it's something that you're doing for compliance, you should probably keep some sort of record that you did it, because all of those things can end up being important in an audit or in a FINTRAC examination.
Yeah, and it's something that we see as auditors. A lot of times companies will say, or staff will say, oh, we did it. If the record is not there, it's almost as good as not doing it, unfortunately, right? So you need that evidence to prove that it's being done. Amber, you can go on to the next slide, which is FINTRAC reporting. So there are certain types of transactions that have to be reported to FINTRAC. They all have different timings. And some of these transactions, or I should actually say all of these transactions, would require you to identify a customer. And again, we'll talk a little bit more about that later. So the next slide is large cash transactions. If you deal in cash and you receive $10,000 in Canadian dollars or more within a single transaction or multiple transactions within a 24-hour period, you have to report this to FINTRAC. You also need to identify the customer, and that information gets populated in the report. Amber mentioned earlier AMPs, or administrative monetary penalties. To give you an idea, if you miss a large cash transaction, report just one, FINTRAC can issue you a fine for $1,000 for everyone that's missed. So that can add up quite quickly depending on what your business model is and how much cash you're taking in. This is also, you know, a lot of times we hear dealers in precious metals and stones say, oh, we don't really take cash, we'll just do it sometimes at a trade show or something like that. The obligation still applies, even if it is on an exception basis. We can go to the next slide, Amber. Large virtual currency transactions. So this is very similar to large cash. This is a new requirement that is coming into effect as of June 1st this year. So if you take payment in virtual currency, such as Bitcoin, similar to cash, if it's valued in $10,000 or more within a single transaction or multiple transactions, that needs to be reported to FINTRAC as well. Amber, next slide. Third parties. So in the cases of large cash transactions and large virtual currency transactions, you have to conduct a determination to see if there is a third party to the transaction. And what this really is a transaction being completed by a customer on behalf of somebody else. It's not meant to capture those situations where you know, I may be shopping for an engagement ring and my partner is there, you know, suggesting which one they like. It's not meant to capture that. These are situations where somebody, a friend of mine, has given me $10,000 or whatever dollar amount to go purchase a Rolex. You need to capture information related to that third party. So you need to have their name, their date of birth, their occupation, and the relationship between the two parties. This part gets filled in on the large cash transaction forms or the large virtual currency transaction form. You do need to keep a record. If there is no third party, which a lot of times there won't be, you still need to keep a record that the question was asked, Again, goes back to what we said about evidence. You need to document everything. We can go to the next slide, Amber. Unusual transactions. If you have reasonable grounds to suspect that a transaction may be connected to money laundering or terrorist financing, you do need to try to identify the customer, and these types of transactions have to be reported to the compliance officer as soon as possible. The compliance officer would then do an investigation and determine if a report needs to be filed with FINTRAC. Some key things to remember here is not every transaction may involve cash. There is no minimum transaction dollar value for these types of transactions. And don't tell the customer that you are suspicious or you're going to be reporting them to the compliance officer. I should mention the large cash and large virtual currency transactions, you're allowed to state to the customer that you are collecting certain information because you have to file this under your AML obligations under law. But it's important not to tell the customer, which is known as tipping off. A lot of times, potentially, if you ask for information, it may tip off the customer. So in those situations where you're in fear of you may tip them off, you don't have to identify, but you do need to record the measures that were taken for trying to obtain identification. Next slide. The stages of suspicion. So simple suspicion is basically you just have a hunch or an instinct or that gut feeling that something's not right. Something might be connected to money laundering or terrorist financing. And going back to the definitions that Amber mentioned earlier, again, this is money that is derived from criminal activity. So if you believe the person may have, come in contact or this money is obtained through criminal means, this is where you would escalate to the compliance officer. The compliance officer would do an investigation, and based on the assessment of facts, context, and indicators that surround the transaction and the customer behavior, they would determine if a FINTRAC report is needed, an STR specifically, if the transaction is completed, but also an attempted suspicious transaction if it's not completed. You can go to the next slide, Amber.
I'm just going to pause here to address a question that came in through the chat, which is how often do we expect an average jewelry store would have someone wanting to spend over $10,000 in cash? It really depends. That's going to be different based on the store, it's where you're located, the demographics that you serve. There are some demographics, some communities that are much more intensive in their use of cash than others. And so the answer is really going to depend on your business. A cash transaction by itself isn't necessarily suspicious, but certainly if it's something that seems out of character, and so this is where you get away from that simple suspicion and move towards reasonable ground to suspect. It's really about what's happening in that conversation. Does it make sense? Does it make sense given your business? Does it make sense given the community that you're dealing with? Does it make sense given the person who's standing in front of you? And so what's normal and what's reasonable is going to have a lot of variance. The important thing is that you need to be able to explain what's normal and what's reasonable for your business. And sometimes that might mean looking back through previous transactions. And another question that just came in is whether or not virtual currency includes EFTs and wires from financial institutions. It does not. When we're referring to virtual currencies, it's really things like Bitcoin. So it's not dollars.
And one thing I'll just kind of add to that. So speaking of large cash or large virtual currency, if your policy is not to accept those types of payments, the other obligations that we're talking about still apply. Suspicious transactions would still, come into context of other types of transactions, other payment methods. So that's important to consider where you may not have that obligation to report large cash or large virtual currency just because you don't accept those payments. The rest of these obligations do apply to your business. So Amber was talking a little bit about this. There really is no single indicator that, works every time. It doesn't mean that, somebody paying $10,000 in cash all the time. It means that a report needs to be filed with FINTRAC. FINTRAC actually publishes a list of indicators which are on their website. Again, just because an indicator is met does not mean there is money laundering or terrorist financing. It does not mean that you need to file an STR, but they are there for context given the situation. If there are multiple indicators, there is potentially a higher chance that you would want to file. And some of these are, a good example is somebody conducting a cash transaction, but just under the threshold of identification, especially if you say, oh, well, I need to collect your identification. That could potentially be one. There are a list of other ones published on FINTRAC's website. And I'm just kind of scrolling through to see if I get some good ones. They're broken down into retail and wholesale, which is really beneficial. So some examples are individual buys high value goods in small denominations of bills. Again, just because they're paying with 20s does not mean that. But if they say, well, I sell drugs on the side and this is where the money's coming from, then obviously you would do a report. So we can go to the next slide. Yeah, and just a little bit more there. So what indicators to look for in a transaction? Again, there's no specific one, but that example that I gave would be for a particular transaction. Terrorist property is the other type of reports that has to be reported to FINTRAC. And what it is here is if you are in possession of any property, whether that be funds or actual jewelry or goods that you might be storing for someone on a terrorist list, it has to be reported to FINTRAC. Terrorist property has to be reported immediately, also has to be reported to CSIS and the RCMP as well. This is probably a very rare report. In my many years of compliance, over 15 years, I have actually never seen this report. Essentially, terrorists know they were on these lists, which are public, so they usually have people, somebody else doing their dirty work for them, so to speak. Sending reports to the compliance officer, as we said, it's important to notify the compliance officer as soon as possible for any suspicious transactions. There are specific reporting timeframes, so to make sure that you are meeting your obligation under law, it's important to notify the compliance officer immediately. And here is a list of the reports that apply to dealers in precious metals and stones. Large cash has to be reported within 15 calendar days from the transaction date. Large virtual currency, which is the new one, is 5 working days from receiving that virtual currency, such as Bitcoin as payment. Suspicious transactions and attempted suspicious transactions are reported as soon as practicable after completing the measures that enable a determination of reasonable grounds to suspect money laundering or terrorist financing. What that really means is it's somewhere in between immediately and as soon as possible once you've completed your investigation. So again, as soon as you investigate, oh, this might be potentially connected to money laundering or terrorist financing, it should be reported. And terrorist property, as I stated earlier, needs to be reported immediately to FINTRAC, RCMP, and CSIS. Amber, thanks. We talked a little bit earlier about tipping off. Here, remember, you are protected under law. As long as you make a report to a compliance officer in good faith, you are protected under Canadian law. So while it's very unlikely that a customer would ever know that you filed a report, even if it goes to court or something like that, you are protected. So no need to worry there. And again, this is if it's done in good faith. If you file a report potentially for trying to get back at somebody that's harmed you, that's kind of outside of the scope, but generally you're protected under Canadian law. and identification. I'll turn it back over to Amber.
Before we do so, David and Amber, we're being asked to share the PowerPoint. The recording will be shared with everyone here online today and the members. So definitely this will come to you, all of you.
And I'm fine with us sharing the slides as well, if
Beautiful.
That's okay with you, Beatrice.
Right, absolutely. So rest assured, everyone, we will be sharing both the recording and the PowerPoint for you to review, and absolutely.
Perfect. And we had a really great question that just came in, which is to say, is it enough to add to your policies and procedures manual that you do not accept any virtual currency transactions, if that's the case? And yes, in fact, FINTRAC has become very critical of policy and procedure manuals that spend a lot of time talking about things that you don't actually do. So if you're not accepting virtual currencies, it's enough to say that your policy is that you don't accept them. Ergo, you don't have any procedures around that. That's perfect. That's the right level of detail. The problem that comes up that I see as an auditor and as someone who writes policies and procedures are those situations where you accept it sometimes. So maybe I don't always accept Bitcoin, but my cousin Jack is just really enthusiastic about Bitcoin. And so sometimes when he wants to buy something, we'll do a Bitcoin transaction. Well, as soon as I make that exception even one time, then I need to have a process around it. And the process might be something as simple as any of these transactions need to be approved by the compliance officer, and the compliance officer makes sure that we have Jack's ID and anything else that we need. But definitely make sure that even if it's just sometimes, even if it's just a one-off, you have processes around those. And
we got another question. We got another question related to large cash transactions. So the large cash transactions, going back to it, it is receiving $10,000 or more within a single transaction or multiple transactions within a 24-hour period. So if I come in one day and I do a cash transaction at 10 o'clock in the morning of $5,000, but then I show up again tomorrow at opening and do another transaction of $6,000, that is reportable because the total is $11,000. And that has to be reported. So those two transactions would be reported as one report, is reportable within 15 days from that last transaction happening.
David, does that answer the question from Ellen in the chat as well?
Yeah,
okay,
that was
perfect.
That was related.
Thank you. And there's another one about the several transactions within the 24 hours from the same customer.
Yes, so those transactions are reportable. So let's say that I'm buying a Rolex and I give you $6,000 in Bitcoin and then another $10,000 in Bitcoin in order to get my watch, and I came in and did both of those transactions on the same day, then that would be reportable because the total amount is over $10,000. So let's jump to identifying customers. And again here, remember that you're only identifying customers in those prescribed situations. So we're talking about virtual currency, so Bitcoin and the like of $10,000 or more, cash, and by cash I mean physical cash, so notes and coins of $10,000 or more, or in the case that you have a completed or attempted suspicious transaction. So those are our three circumstances where we start to talk about customer identification. The most common method of identification in our industry is probably the government issued photo ID method. And so to identify an individual, you can look at a piece of their government issued photo ID. It has to be authentic, which is to say you have to look at it and say, yep, this looks like a real driver's license. It doesn't look like it was drawn in crayon and laminated. It looks like a true driver's license issued by the place it was issued. It's current, it's valid, so it's not expired. It has a driver's license number, and that's one of the pieces of information that you have to keep a record of. The face matches the person, so you have to do a facial match and say, okay, the face on the driver's license is the same as this face. And the name has to match. So if I tell you that my name is Beatrice, but my license says Amber, that's going to be a problem. in terms of the information that I'm giving. So you need that face to match. You need that name to match the identification. Provincial health cards, although they meet all of those tick boxes, in most provinces, with the exception of Quebec, there's actually a prohibition against using your health card as ID in these situations. And FINTRAC is not actually allowed to receive health card numbers in their reports. So if someone tries to give you a health card, you have to ask them for a different piece of ID. Fortunately, all of the provinces have allowed for there to be a special provincial identification that exists for people that don't have a passport or a driver's license. So there's a question that just came in, and again, going back to these large cash transactions, which is if a customer pays in cash one day and then comes back the following week, should it be reported? It doesn't need to be reported in that case as a large cash transaction because it's not happening within that 24-hour period. But if it seems like that customer is specifically structuring that transaction to avoid reporting or to avoid identification, then I would consider reporting it as a suspicious transaction. Any time that they're structuring to avoid reporting, I think it should either be reported as suspicious or you need to keep a documented rationale of why you didn't think it was suspicious. Because it's on you to produce that in the case of an audit or an examination.
Amber and David, I think this is very exciting to see how engaged the audience is. The questions are great, and I have a couple of that were submitted at the beginning, so we're going to go with that. But thank you everyone for being so engaged. That's what we're looking for.
Yes, thank you. So another question on the ID front. Quebec health cards can be used for ID. So there's no prohibition in the province at this point from using a Quebec health card as a piece of ID. For every other province, there are prohibitions. So Quebec, you're okay on health card, everywhere else less so. For now, anyway, those do change from time to time.
Amber, there's another half of that question.
Okay.
So the health card you confirm in Quebec is sufficient, but do they need two pieces of ID or is one enough? One government?
Assuming that you are either meeting with the customer face-to-face and looking at their ID, or you have some type of electronic verification. So for instance, if you're using an app where I hold up my ID and the phone is looking and saying, yes, the face matches the ID is real, they're scanning barcode data, things like that to do a proper electronic authentication, then one piece of ID is fine. If you're doing a thing where you're saying, okay, so, just send us a copy of your ID or a picture of your ID, then you're getting into a dual process verification method where you actually do need something else. It doesn't necessarily need to be a second piece of government issued photo ID. So you could have that piece of photo ID plus something that shows the person's name and address, or something that shows that they have an account, so a financial account with a Canadian financial institution. So that might be something like a credit card statement. Usually though, what people go with for the dual process method is a utilities bill. So something that shows the person's name and address, because you'll already have their name and date of birth from the piece of government issued photo ID. But if you're meeting, again, if you're meeting with the person in person or you're using one of the electronic verifications that's comparing the face to the ID, then you can just use a single piece of government issued photo ID. The other method that you can use that's useful in the online space is what's known as the credit file method. So it matches the person's name and address and date of birth that they've given you to a credit file. The credit file has to be in existence for more than 3 years, and it has to have at least 2 different trade lines. So this works better with certain populations than others because it has to be a Canadian credit bureau. If you are dealing largely with new immigrant populations, then the credit file method is generally not going to be effective because people haven't been here for long enough to have the credit file data. But generally speaking, that's also a good method that's available. So we've got a question that came in terms of apps that verify ID and that are acceptable to use. There are many of them. One of the things that I really like that the Digital Identification and Authentication Council of Canada, so DIAC, has done is actually created a vendor list that they're going to be updating on a regular basis. I believe we have that vendor list in an appendix, but I will make sure that we get that up on screen prior to the end of this presentation. But it's a good place to start going through and sourcing those vendors. And we're happy to provide a list of those as well. In terms of organizations, if your customer is an organization, then you need to collect some additional information. So here you need to collect information about anyone that owns or controls 25% or more of the organization. You also need to ask whether the organization is a nonprofit. And if it is it a registered Canadian charity? Does it collect donations from the public? And a lot of that information you can find on the Government of Canada's website in relation to charities. So if they're saying, yes, we're a nonprofit, yes, we're a charity, then you would want to look up that information as well. If identification fails, so if you're not able to collect or confirm some of the information that you need, then you would need to document the reason for that. And there are certain types of transactions that you couldn't proceed with. So in the case of an individual, if you can't identify them, you wouldn't proceed with a large cash transaction or a large virtual currency transaction. In the case of a company, if you can't confirm the beneficial ownership, then you would need to consider that company to be high risk. And you would need to identify the senior most executive. So for instance, if Outlier was buying gold bars from you and we wanted to pay in cash, then you would need to get documentation about Outlier as a company, who owns the company. And if I couldn't provide it, then you would want to identify me as the CEO. You would consider Outlier to be high risk, and you would perform enhanced due diligence around that. In terms of business relationships, this is probably one of the least understood terms in the industry because it doesn't refer to a relationship between two businesses. It's talking about you as a reporting entity. So as a dealer in precious metal and stones, you have conducted two or more of these types of transactions that require identification. So again, large virtual currency transactions, large cash transactions, suspicious or attempted suspicious transactions. These are your three types of transactions that require identification. If you have two or more of those types of transactions with one customer in the last 5 years, then you have what's known under anti-money laundering regulation as a business relationship. And a business relationship means that you need to decide, is this customer high risk or not? You need to document that. You need to document it whether they're high risk or not. You need to, if they are high risk, monitor their transactions. And so high risk means that there's an elevated risk that this customer could be laundering money or financing terrorism. It doesn't mean that you know that they're a bad guy. It doesn't mean that they're a bad guy at all. But it does mean that you need to take a look at their transactions and monitor those in order to understand if there's anything else that needs to be reported to FINTRAC. You need to make updates to the information related to that customer. So all of those pieces of information that you need to keep, you would update on a regular basis. And you would need to do some type of enhanced due diligence. So depending on the reason that that business relationship is high risk, you would collect some additional information to help you mitigate this.
Amber, if I can stop you for a second, Ontarians shopping in Quebec, is their health card from Ontario acceptable in Quebec?
No, no. If I'm an Ontarian and I'm shopping in Quebec and I'm doing one of those $10,000 cash transactions, make sure that you get a piece of ID that is not a health card.
So the driving license, the Ontarian health card is really not a government ID here, right?
No, it's prohibited from being used as ID.
Yeah.
And this is part of, depending on if you're a retail store and you have frontline, it sometimes gets confusing when it comes to identification with a health card. So we usually advise to stay away from health cards in general, even though a Quebec one is acceptable.
And there's two more questions. The questions are pouring. I love this. As a CJA member, can we have access to a training kit? That's absolutely one of the best benefits we have to offer. As a CJA member, you get access to the compliance kit through Outlier. So absolutely, you are entitled to receive the compliance kit. Would you say the webinar suffices? Not really, Amber and David. This is a great start. And we have another one coming next week and we'll talk about it. They are going to be very helpful in terms of knowing what you're missing, what you have. But as a CJA member, you get the compliance kit absolutely as part of your value of being a member. And these webinars are great. I think we should do more of them, Amber and David. They're quite in demand, especially right now. And we have more questions coming regarding FINTRAC and COVID times. How do they do this during COVID? But I don't want to interrupt the presentations. So I don't, David, do you want to take, do we leave them at the end? Because I don't want them unanswered. You still have a couple of slides to go through, right, Amber?
So this is actually the last one, which is that, David mentioned it previously, but document. From the perspective of an auditor or an examiner, it's not enough to have done something and to have done everything right. It's heartbreaking to me as an auditor when I go somewhere and I believe that the company has done everything that they needed to, but half of it isn't documented. So anything that we're talking about that you need to do here, you need to be able to prove, you need to be able to demonstrate to another human being who does not understand your business, who is not involved in your day-to-day transactions. So it needs to be sufficiently clear. You need to demonstrate that you've done these things. In terms of the question on training, the reason that this presentation alone isn't enough is that you have to train your staff on the way that you do things. So we just had a really good high-level overview. That's an important piece. Slides that are very similar to these ones, and we will be uploading an updated version shortly. So we'll have updates to the compliance kit at the beginning of May. But there are slides that can be downloaded that can be used for your training internally. And what this type of presentation needs to be supplemented with is here's how we do it. So at our store, if you encounter a suspicious transaction, here's where you get the form that you would fill out and give to the compliance officer, or here's where you would go within our IT system to submit a notification to the compliance officer. So what does that process look like for you? And that's something that you need to train your staff on. The other thing that I think is really important is depending on your type of business, you're going to have different suspicious indicators that are more or less important to you. The suspicious indicators that are going to stand out to me, if I am a retail jeweler that does primarily online sales, are very different than if I'm a gold wholesaler who is mostly doing in-person transactions. So what you see is going to be different. What you expect in terms of customer behavior is going to be different. And those are the nuanced pieces that you really want to make sure that you're taking the time to clarify with your staff. I think the best cases to do in training for suspicious transactions are usually the STRs that you've reported previously. So you can talk, not with the specifics of that person's name, but in general about what indicators were present, what you knew about that customer and why it was reported as suspicious at the time.
We have a couple of other questions. So going back to business relationships, the question is, most of our customers buy from us 2 times per year, at least 2 times per year. Do we need to create a business relationship with each customer? So again, going back to the definition, it's 2 or more transactions within a 5-year period where identification is required. So these would only be specific to cash of $10,000 or more, large virtual currency transactions, or if they have suspicious transactions. So any combination of that, two of those types of transactions within a 5-year, they are deemed to be a business relationship. And then what you need to do is collect that other information, which is related to the nature and purpose of the business relationship. We have another question, so related to wire payments of $10,000 or more. Wire payments, nope, that is not reportable unless you feel it is a suspicious transaction, of course. But in terms of that $10,000 threshold, it is strictly cash, so not checks or bank drafts, it's strictly cash or virtual currency such as Bitcoin being received as payment. And we have another question. Yep, go ahead.
Yeah, so we have a question on address. It is fine to have a different address than the address on the ID. It's fine to ship to a different address. But if you're required to record an address, so let's say that I was buying something and I'm paying you in Bitcoin, and then you're shipping it to my office, that's fine. You still need to keep a record of my residential address because of that large virtual currency transaction. So even though what's on my invoice might be different, somewhere within your systems, you need a record that says this, we identified Amber and this was her home address as it appeared on her driver's license.
Thank you, Amber and David. And there's a couple of more questions. We have 4 minutes, but I believe probably we're going a little bit over time, but that's okay.
Sure.
We have to answer all those great questions. One of them is, how do I access my compliance kit? As a CJA member, you contact the CJA office, because in order for us to connect you with Outlier, we need to make sure that you're a member in good standing. So please contact the office to do so. And then the request will go to Outlier for them to assist you. And Amber, that's a good one. How do I print it?
So when you go through, you'll use a tool called the Setup Wizard for the policies, procedures, and risk assessment, because you can't just print it out and fill in the blanks. Your compliance documents really have to be customized to your business. So the Setup Wizard will serve up a number of questions for you. We're working to make that much more streamlined in the release that's coming out in May. So even if you've already gone through it, make sure you go in and do those updates because as we'll be discussing next week, we have some changes coming into force in June, and we want to make sure that you're ready for that. But you'll go through and you'll answer questions like, who is your senior officer and who is your compliance officer? Those will populate into the documents. So once you go through the questionnaires, you'll be able to print documents that are customized to your business model based on the information that you've fed into the Setup Wizard.
And another one, Amber, how do I update my compliance kit?
Once you have access, you can log in anytime. So if there's changes to your business model, if there are changes to your compliance officer, your senior officer, you would go in and update that documentation. So you would just go through the questionnaire again and update the things that have changed and then print new documents.
Even if nothing's changed, it's just important to point out that you should be doing that exercise at least once a year, even if nothing's changed. But to what Amber said, if things have changed in the business model, that should be done more frequently. And
another one, Amber and David, how does FINTRAC audit me now during COVID times?
So FINTRAC had stopped examinations at the beginning of the pandemic for a few months. Back in June or July of last year, they resumed doing examinations. The difference is they are not in person. So typically, just for background, there's different types of examinations. They can be in person. They could be at a FINTRAC office, which is probably really scary, or they can be done over the phone. So right now, the phone is pretty much the option that they're going with. And what that looks like is that you would get a notification that FINTRAC is going to conduct an examination. And then you have a time period in which you need to provide documentation from them. And then they would set up a phone call with you to go through the documentation and ask questions.
Thank you, David. And another question that came through is, can someone walk me through helping me with the compliance kit? We definitely offer this as a possibility and as a solution, but we will connect you with Amber and with her team to do so. It's not, Amber, would you like to elaborate on that?
Sure. So in so much as we've worked to set up the kit online to be simple and straightforward, it still does take time to go through. The online version of it is free. If you need consulting time, then there are fees associated with that.
Right. When you refer to cash as 10,000 or more, can it be in any currency as long as the value is $10,000 or more Canadian?
That's correct. Yep.
That's correct. Okay. Just to confirm, how long do we need to keep the information before it can be destroyed? I think you mentioned 5 years in the presentation, David.
5 years.
Yeah, 5 years. And then it's 5 years, but depending on the type of record, you know, for something submitted to FINTRAC, it's 5 years from the date of that report that was, you know, it was submitted. But if it's related to customer identification, it's 5 years from the end of the relationship with the customer. So 5 years, yes, but it depends on the trigger point, so to speak.
And that's another great question. If a customer is reported several times to FINTRAC, can we continue receiving large cash amount from him, her?
You can. So there's nothing in the law that says that you have to not do a transaction. However, you will get questions in the context of an audit or in the context of a FINTRAC examination about why that customer is still within your risk tolerance if you're continuously reporting it as suspicious. So there is an idea that at some point you would consider that customer to be too risky if you were reporting all of their transactions as suspicious. There is also nothing in the law that says that you have to put yourself in harm's way, which is to say that if there is a point where your sense is that this is someone that is going to respond violently, if you do not complete the transaction, complete the transaction and write in your report that you believed that the person would respond violently if you didn't complete the transaction. And this is where just document. But there is an expectation that at some point a person might be outside of your risk tolerance and you would stop doing business with them. Again, this is not an expectation that you would put yourself in harm's way. So if this is not something that you believe that you can do safely, then you shouldn't do that. Similarly, the suspicious transaction reports aren't something that's admissible in court, which is to say that the police build their cases around information from a number of different sources. And what would generally happen if they were looking at a suspicious transaction report that ended up being important to them is that they will actually send you something called a production order, where they're actually formally requesting the information in a way that that information can be submitted to the court. And what's seen in the context of a trial is that the police requested that information, the business provided that information. Most of us don't say no to official police requests for documentation provided that they're reasonable.
Yeah.
And Amber, sorry, go ahead.
I was just going to say, if anybody's afraid from a privacy perspective that they don't want to provide such information, there are carve-outs under Canadian privacy law that allow that type of information sharing on a production order or something like that.
Thank you, David. Thank you, Amber. Do I have to have a compliance kit if I import from abroad?
I mean, assuming that you are selling jewelry or precious metals and stones in Canada, the point of origin doesn't matter. You would still need to have a compliance program.
Okay, great. And Amber and David, thank you very much for this very valuable session today, but we have another great one in a week's time from today. So could we tease a little bit the audience of what next one will be about? Because we don't want them missing that one either, do we?
Definitely. So we'll go a little bit more. We talked about large virtual currency transactions, which is new. We'll go a little bit more into depth on exactly what that looks like. But there are also other new requirements or amended requirements that are coming into force as of June 1st. And we'll talk a little bit more about those. So we talked a little bit about that business relationship. There's going to be certain other obligations related to that start as of June 1st. We talked about organizations. If you have customers that are entities or corporations, you need to collect certain information. So there's some changes there. We'll talk about that a little bit more. So yeah.
Thank you for that, David. Amber, anything else to add today before we recoup again in a week?
Just a big thank you to David for being a wonderful co-presenter. And we have the link to the DIAC piece on identification that we mentioned in the chat for anyone that wants to connect with that.
Wonderful. And thank you to my fabulous panelists today, Amber and David. And we'll see each other in a week's time. And to everyone out there, we thank you for your time. We know everyone is busy, especially during these difficult times for all of us, but we ask you to stay well and healthy, and thank you for giving us an hour of your time today, and we hope to see you in a week to learn some more about AML from our